Good morning, people. Good morning. What is this? We're Wednesday. Happy Wednesday to everybody. This is where they call today hump day. But me not see nothing, not this day we call hump. Not we know what the hump day mean. But anyway, coming to you from Bitcoinist. Bitcoinist is saying big news for Ripple as Department of Justice call cryptos commodities. As the legal battle between Ripple Labs and the SEC and the U.S. Security Exchange Commission draws to a close, and all eyes are on Judge Annalisa Torres, the U.S. Department of Justice may have provided another argument for Brad Garlinghouse and his company. In recent court filings by the U.S. Department of Justice against Avraham Eisenberg, the DOJ refers to two cryptocurrencies as commodities. Eisenberg, who exploited the decentralized finance platform Mango Markets and made 67 million, was arrested yesterday in Puerto Rico and charged with market manipulation. I know that Mango Market. I actually saw it and I was looking into it and I just didn't invest in that. So, reason to cheer for Ripple. For XRP investors and Ripple Labs, the indictment is interesting in that the U.S. Department of Justice calls the two cryptocurrencies CRV, is that Civic? CRV and Mango commodities rather than securities. At no point do the DOJ lawyers refer to cryptocurrency as securities, nor do they refer to violations of securities law. Look at the document of justice is calling MNGO and or CRV commodities and not securities. So I wish I could have zoomed in without it wanted me to click on it. I don't want to go to Twitter. I don't want to go to Twitter. You know what I'm saying? So guys, if you want to look at the document, there's a link. Go to Twitter. Go check it out for yourself. For the Department of Justice, it thus appears that there is no dispute neither token should be classified as security. This stands in stark contrast to SEC Chairman Gary Gensler, who is not only leading the case against Ripple, but has also opened on several occasions that pretty much every crypto token is a security. In the indictment, the Justice Department writes unequivocally of CRV and MNGO tokens as commodity, it states. So here it is right now, the Jamaican Vice. This is coming from Avraham Eisenberg. The defendant willfully, unknowingly, directly and indirectly use in connection with swaps a contract of sale of a commodity in interstate and foreclosure commerce and for future delivery on the subject to the rules of the registered entity, a manipulative and deceptive device and contrivance in contravention of Title 17 Code of Federal Regulations. Why them all have to use such big words? You can't be simple. So now you have to look up what all of these words mean to even understand what this person is saying. Guys, forgive me. I literally just opened my eyes. And this is what I do, man. I open my eyes and I check out the articles, and relax a little bit before I get up out of bed. You don't want to just rush out of bed unless you have to pee or something. All right. Remarkable, these documents were filed by the U.S. Department of Justice in the Southern District of New York, the same court where the case between Ripple and SEC is taking place. It is all just strategy. It's a question. Gabriel Shapira, general counsel at Delphi Labs, commented that the fact that the case does not classify the relevant tokens as security is no way positive. According to Shapiro, the classification is simply a result of litigation strategy. The fewer predicate issues the government has to litigate in its case, the better. Scott Lewis, co-founder of DeFi Pulse, agrees with Shapiro and stated that the government is not announcing a new policy towards token with this document. Nevertheless, inconsistent policy towards crypto tokens is evident, he says. All government policy is a litigation strategy, including Ripple and LBRY enforcement actions. I believe that. I believe that for sure. Me personally, I believe that. So Matt Feinberg, an attorney at Falcon Rappaport and Berkman LLP, added, maybe, but that's because they believe it's easier to prove that it's a commodity, which infers that the commodity theory makes the most sense from a practical standpoint. Also, keep in mind this is the DOJ choosing to use commodities law, not a CFTC enforcement action.